Let's take a look together at one of the ways that Judge Aileen Cannon, the federal judge in the Southern District of Florida, is using paperless orders to cause massive delay in the federal criminal prosecution of Donald Trump in the Southern District of Florida. I'm Ben Meiselas from the MeidasTouch Network. Let's take a look at a paperless order that Judge Aileen Cannon issued on November 3rd, 2023. And then I want to show you some of these other paperless orders and show you how she is using these things to delay the case. And when you read these paperless orders, it may not look like there is a massive impact taking place, but it is. And she's doing this precisely because she learned all the wrong lessons from 2022 when she was reversed by the 11th Circuit Court of Appeals in another case involving Donald Trump, right? In the other case relating to the search warrant in 2022, she was overruled twice by the 11th Circuit Court of Appeals in scathing orders by the 11th Circuit Court of Appeals. And now what Judge Aileen Cannon's doing is like she's not actually issuing orders. Instead, she's doing these piecemeal paperless orders in Special Counsel Jack Smith's federal criminal prosecution of Donald Trump for the willful retention of national defense information at Mar-a-Lago and Trump's obstruction of justice. So take a look at this one, November 3rd, 2023. Paperless order on notices. The parties are hereby reminded of the requirement of Local Rule 7.8 on notices of supplemental authority. Except as authorized by court order, the substantive content of any such notice or response may not exceed 200 words and may not be used as a surreply absent leave of court. Future non-compliant notices or unauthorized filings will be stricken without further notice. Signed by Judge Aileen Cannon, November 3rd, 2023. Now, this paperless order may not seem like it has a major impact, and it may be confusing what this even means, but it's a real attack on Special Counsel Jack Smith. And trust me, Special Counsel Jack Smith's team understands the message being sent here, as does Donald Trump's team. This is very favorable to Donald Trump. Let me explain why. On November 2nd, one day before this paperless order, Special Counsel Jack Smith's team pointed out to Judge Aileen Cannon something profoundly important. There was a hearing held before Judge Aileen Cannon on November 1st. So one day before this notice was sent to Judge Aileen Cannon, and Special Counsel Jack Smith's team pointed out on November 2nd that when Donald Trump's lawyers were asking on November 1st to delay all of the dates and the hearing schedule and the trial dates, they did not inform Judge Aileen Cannon that they were also going to be requesting a stay of the proceedings in Washington, D.C. in the federal criminal prosecution regarding Trump's attempt to overthrow the results of the 2020 election before Judge Tanya Chutkan. One of the main arguments that Donald Trump's lawyers made to Judge Aileen Cannon on November 1st to try to request all the hearing dates be removed is, look, we've got this March 2024 hearing date in federal court, or trial date rather, in federal court in Washington, D.C., and that's etched in stone. And so that affects this trial, and therefore you need to move these trial dates in Southern District of Florida later on, maybe late 2024, 2025. Just move the dates, Judge Aileen Cannon. Help us delay the dates. But what the Trump lawyers then did right after making that argument to Cannon is they went right into Washington, D.C. and asked Judge Chutkan to stay or delay the case there. So this notice on November 2nd is just Special Counsel Jack Smith's team telling Judge Cannon, look, Trump's lawyers lied to you at the November 1st hearing. They acted like no matter what, it's a foregone conclusion that the case in D.C. starts in March of 2024. And then after lying to you, Judge Cannon, you should care about them lying to you. They made a filing right away in Washington, D.C. saying move those deadlines. That's why, Judge Cannon, we told you as the special counsel's office that you need to keep your trial date of May of 2024. Do not delay the dates in your case, because we don't know what's going to happen in the various cases. Yes, sure, if the March 2024 case does go to trial, and maybe it does, we expect it to, but we just don't know what's going to happen, then you can delay your trial. But they're going to try to do things to delay that March 2024 date in D.C., so there is no reason to move your dates. And Trump's lawyers were like, no, we're not going to do that. And then that's exactly what they did. So this notice filed on November 2nd is saying, Judge Cannon, see, we told you so. And rather than Judge Cannon saying, Thank you. You caught them lying. Great work. Or I was lied to. Judge Cannon's response is not that. Her response is basically saying to the special counsel team, to the government, I'm not going to read this. That I am reminding you, don't send me these notices. And that if you want to give me these types of notices, request it formally. Maybe I'll grant it, maybe I won't grant it. But you telling me on a notice that they're lying, I'm more upset with you for filing the notice than I am at them lying. I'm not even mad at them for lying. I mean, think about the import of that. And then Judge Cannon followed that up with this paperless order, paperless minute entry for a proceeding held before Judge Aileen Cannon. She talks about a hearing being held on November 1, the one I just told you about. The court heard arguments from the parties on defendants' pending motions to continue. Trump wants to delay all of the dates and deadlines. And then the court says, and this is what Judge Cannon says, the pretrial deadlines are temporarily stayed pending order to follow. Look at the highlighted language there. Pending order to follow. So she doesn't even issue the actual order. Instead, she issues this paperless minute order, this paperless minute entry that just shows up on the docket. So now put these two things together, right? There was the first paperless order on notices, criticizing special counsel Jack Smith for informing her that Trump had lied in the November 1 hearing. And then she files, Judge Cannon does, on her docket, this paperless order that pretrial deadlines are temporarily stayed, pending order to follow. Now, why isn't she issuing the order? One of the reasons that she does these paperless orders, compare like this. These paperless orders, these paperless entries, there's no citation to cases. These are not actual like orders. They're just docket entries. Compare that to what Judge Tanya Chutkan does in Washington, D.C., and what federal judges with experience actually do is they issue orders that have citation to cases and explain the facts and explain their reasoning. They put in the work and they then file their orders on the docket, and the orders have a binding impact and effect. What Judge Cannon is doing here, though, is just saying, I'm going to stop the deadlines and then maybe I'll issue an order at some point in time and give you more of my thoughts. But for now, all of the pretrial motion deadlines are delayed. And by the way, on Friday, the same date she issued this minute entry, Trump was facing a deadline to file pretrial motions to dismiss, like the substantive motions were due. So she's taken away all of the discovery deadlines, the classified information discovery deadlines. She's now delaying the main substantive deadline. She's halted the case, but has not actually issued a real order. She's just issued these paperless orders. Here, let's go take a look at some of these other paperless orders that she issued. Here's one, October 6th of 2023. So mind you, for the very first time, Judge Aileen Cannon signed the pertinent CIPA protective order, Classified Information Procedure Act protective order, on mid-September of 2023. It took her like 3 months to sign that protective order. By waiting that amount of time, Jack Smith couldn't turn over any of the relevant classified discovery until Judge Cannon signed the protective order. And so she waited and waited and waited. Just think about that. She waited 3 months to sign the main substantive protective order. It took her 24 hours to attack the Department of Justice on November 3rd when they filed a notice calling Trump out for lying on November 2nd. Just put it that way. But then after finally waiting 3 months to sign the protective order in the case, then on October 6th, on her own, this is what Judge Cannon does. Paperless order, another one, temporarily staying CIPA Section 4 deadlines pending consideration and resolution of defendant's motion for a revised schedule for motions to compel and CIPA. So she's saying that She's temporarily staying the deadlines. She's doing that on her own on October 6th. Again, a paperless order. Boom. Here's another one. Paperless notice scheduling hearing. This is on October 19th, right? So 13 days after that October 6th paperless order staying the deadlines, here is what she then writes. She schedules this hearing November 1, 2023. So she waits like 10, 11, 12 days after she even does this paperless order, schedules a hearing in Fort Pierce, and then says defense counsel and attorneys for the Office of Special Counsel must be present. The October 2023 deadlines set forth in the court's scheduling order are temporarily stayed pending this hearing and further court ordered, right? So October 6th, paperless order, staying her deadlines. October 19th, paperless order, staying the deadlines. You drag that onto a hearing in November 1, 2023, and then you follow that with your paperless order on November 3rd, staying or stopping all of the relevant deadlines, removing all deadlines, and not actually filing any substantive order at all. So you just watch what she did over the course of the 3 months, doesn't sign the protective order, finally signs the protective order, paperless order, staying all deadlines, paperless order, staying all deadlines, paperless order, staying all motions. And that's how she's basically imploded her docket, and she's trying to stop special counsel Jack Smith from filing any appeals because she hasn't really issued substantive orders to allow him to do that. Instead, trial judges have the discretion of their docket to do scheduling, things like that, right? So under the auspices of scheduling, she's actually making major substantive moves. So again, the main lesson that she learned when she was embarrassed and humiliated by the 11th Circuit Court of Appeal back in 2022 for her orders claiming equitable jurisdiction over the search warrant, that was a whole separate case. She's like, if I just delayed, I would have helped Trump out more there. So now, rather than saying, you know what, I should follow the law, she comes up with ways to try to screw special counsel Jack Smith. And she's not giving a specific date yet about moving the trial. Let me tell you why. She is going to try to delay to try to screw over Fulton County District Attorney Fani Willis, because one of the things Judge Cannon realizes is that if she pushes the current trial date, which is May of 2024, out later, Fulton County District Attorney Fani Willis is going to come in and try to get that May or June trial date there for the Georgia criminal RICO case. So that's Cannon's strategy right now, and you can see it exposed through these paperless minute orders. And I know that may have been a tedious exercise to go through that together, but it's important that you see what is going on here in these very specific minute orders. You know, that's how corruption often exists, in the minutia, in the details. That's why we have to dig into it together this way. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.